You are
Lisa.
Lisa Rubber. Okay, and your name, sir?
Brown.
Before this courtroom even begins, the tension is thick. Judge Simpson enters, ready to cut through a tangled mix of property rights, harassment claims, and bitter personal history. What you're about to witness isn't just a landlord-tenant dispute. It's the emotional wreckage left behind when trust between neighbors implodes. The defendant, visibly strained, insists he was forced out due to harassment and bullying, while the plaintiff's side pushes for closure and possession. This case turns into a perfect example of how the smallest property disagreement can spiral into accusations, fear, and courtroom chaos. Pay close attention to how Judge Simpson methodically pulls truth from confusion, using calm authority to separate emotion from legality. As we begin, ask yourself, who's really the victim here? The man claiming harassment or the woman alleging abandonment?
All right. And is Melinda Brown here?
No, I have a letter giving me a power of attorney for her.
That won't work, but
She has thyroid problems and her blood pressure's
No,
at 200.
that's fine. But okay, I understand.
It's
all right.
bad.
It may not matter, Your Honor.
Okay.
I understand from my review of the prior proceedings, although I did not watch the video, that and the fact that the defendants delivered keys to the premises to Ms. Reppert. So I understand that they are not claiming possession. Sir, Your Honor, I don't want to start a fight with him, sir. Have you moved out?
Because I forcefully cannot go there because of the harassment and the bullying.
So, Your Honor, I guess it's a
gave
yes or no question.
I
Have
gave
they
the
surrendered
keys up.
possession?
So have you moved out of the premises, sir?
Yes, back in July.
Okay, and you gave keys to the plaintiff?
I put keys in the doors when I was last there and text her the keys were in the doors.
Okay, so
It was no longer safe to be there and I had to carry a weapon when I went there and stuff, so I figured it was time to go.
After this line, the mood shifts sharply. Carrying a weapon to your own home isn't a casual statement, it's a cry of fear. In legal terms, this testimony strengthens his argument that the premises were unsafe, possibly giving him justification for surrendering possession under duress. But it also raises a red flag. Self-harming and civil disputes can complicate things fast. Judge Simpson's composure contrasts the defendant's emotional unraveling. He's not dismissing the fear, but he's keeping the focus narrow, possession, not personal grievances. This is a masterclass in courtroom control. If you were in his position, would you walk away or stand your ground?
okay, but I sort of understand that. What I'm trying to figure out is you voluntarily surrendered. While you didn't physically give the keys to her, you put the keys someplace, told her where the keys were, and now is Melinda your wife?
Yes.
Okay. So now you and your wife are no longer in the premise.
We haven't been.
Okay.
July.
So you're someplace else.
Yes.
Okay. And so let me ask this. Are you claiming a right to be in the premises or?
There's more involved in the lawsuit.
Yes.
I claim that I am out of there. That's fine. I don't mind not ever going back there, but she has a lot of fraud and
Okay.
lies.
I'm not to that portion.
Okay.
But so as to the issue of possession, it's done.
Well, I have stuff there.
Okay. Okay, so when you say stop, what do you mean?
You probably don't know this and they're probably not telling you, but I got a sheriff's sale notice in June. 2 days later, she come pushing to get me out.
After this moment, the story gets layered. The mention of a sheriff's sale flips this from a domestic dispute into a potential foreclosure context. It suggests the property itself was already in legal flux, meaning both parties may be reacting to external financial collapse, not just personal conflict. Judge Simpson knows this matters. It reframes who actually had control over the premises. If the home was subject to a sheriff's sale, possession might be a legal illusion. Neither side truly owns stability. This kind of background is where courtroom drama becomes human tragedy. He's not just losing a house. He's losing security, dignity, and trust.
Okay.
So I frantically tried to find a place to live for my family and get them out of harm's way. And I can't move all my stuff. So and every time I go there, I get bullied and harassed by her enforcers over here and her.
Your Honor, for the record, he's talking about these two nefarious looking, dangerous looking people seated in the front row to your far right.
All of them?
Just the two on the two on the far right.
Oh, okay.
Not Miss Dude.
Oh, because it was the one in the red I was worried about.
I understand.
All right. So,
Can I say something?
sure. Go ahead.
I've been watching my 2-year-old grandson, so my daughter could go back to work. She got fired from the COVID for not taking the shots at 8 months pregnant. So I started watching them like 4 months ago so she could go back to work. And they show up anytime they want, go through the buildings, harass me, tell me I'm stupid. I'll never get a lawyer.
Sure. I can't.
So
I don't know that I can do anything about that right
yeah,
now. But
that's fine.
here's what I'm trying to figure out. You surrendered possession, it seems to me, based upon what I'm hearing. But then you've indicated that you still have stuff there.
Yes.
So what I'm trying to figure out, at least at this point, to try to at least get this case to a certain point, is how long do you need to get the stuff that you say is there out?
Well, she told me that
I'm not asking what she told you.
I just mentioned.
No. Answer my question.
I'm not sure. I can't get anybody to go back there. So it's just me, myself, and I have to do some hauling. And I have MS, so I get these bouts of things that just.
Sir, I'm gonna either ask you how much time you need, or take your hand out of your pocket, sir.
Oh, I'm sorry, I just got these. I would say I can't do it until next month after I get paid. Because I have to take some stuff to the.
So what date is that?
I get paid on the 3rd. And it's gonna cost me $300 or $400 to haul things off.
After this exchange, we see another layer: financial strain. The court often sees these figures as trivial, but for many defendants, for $100 might as well be for dollars. 0. Judge Simpson listens without pity or impatience. He's balancing empathy with procedure. The mention of multiple sclerosis (MS) is crucial. It adds medical vulnerability to financial desperation. Yet, the judge redirects him, staying objective, requiring timelines and facts. This is the heart of courtroom realism, even when emotions flare. The legal system demands precision. No chaos, no stories, just answers.
Okay.
And a lot of the things that I'm accused of is not mine.
Sir, I don't know what the accusations are
Okay.
anyway, other than those folks are bad.
Yeah, say something, Your Honor.
Oh.
It's just about the property. It's all outside. There's nothing in it.
Okay. So you need to the 3rd because you get a check at the 3rd.
Well, it'll take maybe a week to haul stuff out because I have to load and haul. And there's things that are said that are mine that if I would have took those with me, it'd have been grand larceny. She's saying that I left stuff there that's hers.
I don't know what that meant.
A 3-acre horse corral, all the posts and fencing, washer and dryer that was damaged by storm down in the basement, that's hers. that claim that I left there. And there's quite a big,
That claim that you left there.
yes.
Okay, let me ask you this. Do you want the horse fence? I
No,
don't think you get the horse fence because that's now, if it's in the ground, become a fixture to the
no, it's
property.
been taken out. She told me I could go ahead and take it out so I could mow everything.
This exchange captures the bizarre beauty of civil court, where fence posts become legal puzzles. Fixture's law is simple. If it's attached to the land, it belongs to the land. But human logic says, I built it. It's mine. Judge Simpson coolly clarifies that once it's in the ground, it's part of the property. A clean but painful truth for many homeowners. The defendant's confusion is relatable. He's trying to draw moral lines inside legal boundaries. This is where the law often feels cold. It values structure over sentiment.
But that's her property. I can't just take it.
Okay, and the washer and dryer?
That's
I see your hand.
Storm damage.
And so you want to take it,
No, I just don't want.
so you're going to leave it there?
Yeah, it's still there, and I don't want it. I don't want the horse corral or the fencing.
And that's still there?
Yes, that's hers,
Okay,
and the camper. That's hers.
and it's still there.
Yes,
So if you go to move stuff and you leave it there, then it's just there.
yeah,
Yeah.
but I don't want to be charged for her hauling that away, which you're trying to do, as damages. They're claiming I left it there. It's not mine. I didn't leave it there. I left it there
Oh, so you don't want to be charged for the disposal if she doesn't want to
of
do
her
it?
stuff. Yeah.
Okay, well, we can deal with that at some later point. You, Mr. Fink, have been conspicuously silent. So is there something you
It's
want?
been an effort, Your Honor. Can we start with the house? Do they claim to have anything in the house, or are they done with the house?
All right, stop there.
Done.
The house is done.
Done.
So you've surrendered the house, they can go into the house. All right, good.
After this ruling, the courtroom energy loosens. For the first time, something is decided. The house itself is done. Possession has shifted. Yet instead of relief, there's exhaustion. Judge Simpson's tone softens slightly, not sympathy, but closure. He sees both sides drained, tangled in their own grievances. Here's what's remarkable. Even when he restores order, the human mess lingers. You can almost feel the silent admission that this conflict was never about property. It was about power, hurt, and control. Do you think Judge Simpson handled this moment fairly? Or should he have pushed harder for reconciliation?
She's already living there.
So
Okay.
you guys know way too much about each other. Okay, so she's there. It's her house. Yes, Mr. Fink.
I'm trying I think that maybe three of us are working in the same direction of just trying to figure out how we can wrap this open case up. And so in terms of what he says he needs to go back to get, I understand that the date is a moving target, but maybe we could talk about what it is that he is claiming he is his, or what he can get, so we can see if there's any issue. Because I'm thinking that if we can get to there's no dispute and we have a good record here and in the ROA, that maybe, I guess we wouldn't want to dismiss this yet until we're all done, but
Oh, I do.
yeah, I know you do.
But-
That was my plan and my hope also, Your Honor. But so, and I don't want to argue with Mr. Brown, but if we could get a sense of what he says he needs to get, it might be helpful.
I got a hot tub, shrink wrap.
All right, okay, great, dude, let's do this. Let's do this. You know what you want to get off the property, right?
The things that I left there, yes.
Okay, so why don't I pass this case? Why don't you take time to write a list of the things that you want off the property?
After this, Judge Simpson pivots from mediation to management. His instruction to make a list isn't bureaucratic, it's strategic. By forcing the defendant to specify, he's transforming chaos into evidence. Every civil case needs this pivot. The moment emotion is converted into documentation. Notice how the defendant resists clarity, saying it's mostly garbage in a camper. This reveals a deeper theme: emotional fatigue. People reach a point where ownership no longer feels worth the fight. Simpson senses that, yet he keeps him tethered to the legal process. This is why courtroom judges must blend psychology with law. They can't heal disputes, but they can contain them.
It's mainly just disposal.
Ooh. I need you. That was a legal term. I need you to get a piece of paper. You got paper there. If not, we'll provide paper and a pen. I need you to write out those things which you want off the property.
Can I just say what I don't want? And everything else can go?
Can you follow what I just told you to do?
I can't, because everything is pretty much stuff that we threw into piles when we had to leave. I got out of the house. So it's mainly garbage and a camper and a.
You want the well, you said the camper was hers.
There's two there. One's my son's.
Okay, so that would be something you'd want. You want the pile of garbage?
Yes.
Okay, so where's the pile of garbage located? Does anybody have any pictures?
Yeah, we have tons.
Pardon?
We have tons.
Oh, joy. So, tell you what, you're still going to write a list of what you know that you want.
Here, tension peaks under politeness. The defendant's confusion over what's his versus what's garbage underlines a core issue. When people live through eviction or forced removal, property becomes symbolic. Every item carries resentment. Judge Simpson's sarcasm toward Mr. Fink, "That's probably the first time I've ever said that," breaks the monotony. A flash of dry humor in court reminds everyone this isn't warfare. It's procedure. The audience should notice how skillfully the judge keeps order while humanizing the process. He neither mocks nor indulges the defendant. He simply keeps the train on the tracks. Do you think humor helps de-escalate tension in court, or does it make things feel dismissive?
You guys go find your pictures, okay? And then we'll try to figure out what it is. This may take a minute, but I think Mr. Fink's right. Let's figure out. That's probably the first time I've ever said that.
Sorry, I didn't hear you.
No, you're not going to get it again. And then we'll just figure out what you're intending on taking. Got it?
Yes, sir.
Go make your list. You guys go find your pictures, and then we'll call it back up. Golf side leg. No. There's a room outside. Oh, yeah, just go to the room outside and write that down. And then, your name again, sir?
Leon Brown.
All right. So, did you do a lit? You need to take your hands out of your pockets.
I'll just sit down. Your Honor, I have had a second thought. I don't want to go back. It makes me sick. I'm sick from being around these people after what I've been through. I just want to get this over with, get going.
This statement marks emotional surrender. The defendant's words, "I just want to get this over with," signal a full collapse of will. In legal reality, it's the closest thing to closure, but psychologically, it's resignation. Judge Simpson immediately pivots to finalize possession. The system thrives on finality. Done is the most powerful word in court. Yet you can sense the sadness behind it. No victory, just exhaustion. What's interesting here is how civil justice often ends, not in triumph, but in fatigue. That's the price of peace in property law.
All right.
It's simple.
Got it. So as to possession,
It's over.
whatever's there, okay. We can do that. Now there's a money claim also. Go ahead, Mr. Fink.
As long as the record is clear that Mr. Brown has surrendered possession of all the premises and has abandoned anything else that is there. we can dismiss once that record's made, we can dismiss the entire case without prejudice. And Ms. Reppert will assess her damages and decide whether to proceed in small claims or pursue him in a general civil action.
All right. You understand that, sir, or no?
There was as much stuff there when I moved there that I had to clean up for 2 months. The gantry sheets, 5 truckloads in the basement, the beds, the couches, had to move her out, move me in. I think we're even. Let's just go. It's over. There's no damages. This is extortion.
Sir. All right, let's break this apart.
Excuse me.
You are giving up possession of the premises, correct?
I am.
All right, and that would include the entirety of the leased premises. Whatever you were there,
Yes,
okay.
yes.
And that any property that's there, you're giving up any claim to any property that was
Yes.
left there, correct?
Yes.
Is that right?
This is the defining legal moment. Once the defendant agrees, the court transcript locks it in forever. Surrendering any claim means there's no coming back. He's waiving future rights, knowingly or not. Judge Simpson takes extra care to ensure comprehension, signaling his integrity. Even though the man wants it over, the judge ensures consent is informed. This illustrates why judges must serve both law and conscience. A rushed signature can destroy years of ownership. Simpson's precision ensures that when the gavel drops, no one can claim confusion.
Okay. Is there anything you do not understand about that surrender of possession of the premises?
No.
Okay, all right. Now, Mr. Fink has also indicated that they would dismiss without prejudice the entire claim, so there wouldn't be a money judgment going along with this at this time. After inspection of the premises, should the plaintiff choose to pursue in small claims court a claim against you for damages, she could do that. All right. You would have at that time the ability to raise those claims that you're raising now. So, for example, that you moved her in or that you had to do other things, whatever you think might offset any monetary claim.
I would like to get it settled now because there's no damages either way.
Okay, so, all right. I get that. But the problem is I don't know that that's going to be able to occur because I don't know that she's done an inspection of the premises.
She's living.
Hold it, sir.
I'm sorry. Go ahead.
Thanks, it's my court. I appreciate it.
Have we settled the issue of possession?
Yes.
Even with Mrs. Brown not present,
Well, yes, that's going to be a problem because,
well, if we have Mr. Brown sworn that and he asserts on the record under oath that they have surrendered possession and claim no right to possession. And then the next part is, let's give the plaintiff 30 days or 45 days to amend the complaint, give them time to answer, and then you keep jurisdiction and we'll just come back on this money claim, or we would, if we decide not to amend the complaint, submit a motion to dismiss. But that way he doesn't have to worry about something hanging over his head, whether it's going to happen, and we can just keep proceeding with this case.
all right.
I didn't want to do that, but it sounds like he would be more comfortable just proceeding.
Well, I don't think that's what he wants to do, actually. I think he wants to end it, but he wants to end it without, well, let me ask this. Are you living in the premises?
No, sir.
You're not? Okay. Yes.
She was there last night, house wide open with her dogs, all
Okay.
there.
I was doing your.
All right. I'll know too much about each other first thing. Sir, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. The questions that I asked you regarding surrender of the premises, all of those answers are correct?
Yes,
and you surrendered the premises and are abandoning any property that's contained on the
Yes.
premises. Okay. With reference to Melinda, she has also no longer residing in those premises, is to your understanding?
yes.
All right.
And has given me permission to have the case.
All right. Are we going to do this by way of a conditional dismissal, or how are we doing this?
My original thought was we just dismiss the case without prejudice.
Got it. I see what you're saying.
And then if this Robert decides to pursue a collection case, frankly, I think it's unlikely that it's cost effective to retain me to do the collection.
That's what you do. Okay.
But if she does, she won't be prejudiced.
Got it. Okay. Did you understand that part, sir? So here's what's happening. Here's what would happen if we agree to this. This case would be dismissed, which is what you want. Subject to one thing. Should Ms. Reppert decide that she wishes to pursue a claim for money damages, either for damages, for whatever, okay? And certainly you may disagree with that. She would have the right to do that.
And me also.
You would have a right to assert any defenses or assert any claim. But as for this case would be dismissed without prejudice, understanding that you and your wife have given up possession of the premises. That would work for you?
Yes.
How about I submit I think it's an MC09 dismissal. Under the 7-day rule, it includes a line that says conditions defendants have surrendered possession without prejudice. And I'll submit that to the court on the 7-day rule. I'll just need Mr. Brown's address for dismissal.
All right. Would that work for you?
We can use my post office box.
That's fine with me, Judge.
That's
I
fine.
don't want these people knowing where.
Okay.
Sure.
Okay.
PO box is good. You have it.
You have his PO box? Okay, so she can get that to you. All right. Very good. Thank you, folks. Case dismissed. You're welcome.
Thank you.
Thank you.
And just like that, the case ends. Judge Simpson dismisses it without prejudice, meaning either party could reopen certain claims later. Legally clean, emotionally messy. Both sides walk away bruised but freed, at least on paper. What makes this hearing so fascinating is how the judge maintained empathy without losing control. He balanced compassion with clarity, ensuring every admission and surrender was voluntary. This case isn't about winners or losers. It's about closure, even when closure feels hollow. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns.